Welcome to Coffee and Regs, a CSS RegTech podcast series on moving from a tactical to strategic approach to regulatory compliance.
Hi, this is Natalie Silverman for CSS. Welcome to our next episode of Coffee and Regs. On today's episode, we're discussing shareholding disclosure rules for managed holdings and why obligations across jurisdictions can be even more difficult for investment managers than staying on top of regulatory change. Please welcome CSS's Regulatory Content Manager, Greg Hotaling, and Head of Shareholding Disclosure at aosphere LLP, an affiliate of Allen & Overy LLP, Faye Sutherland. Good morning, Greg and Faye, and thanks for sitting down for Coffee and Regs.
Thanks, Natalie. Greg Hotaling here from CSS. And I have with me again my colleague, Faye Sutherland from aosphere. She helps us a lot, and aosphere, in fact, helps us a lot here at CSS with the legal content that we provide to a lot of our clients. And today we'll be talking about a topic of particular complexity, I think, for those interested in shareholder disclosure rules. And that is managed holdings and how you need to attribute your interests across your funds that roll up under you if you're an investment manager. Faye, did you want to introduce yourself very briefly?
Sure, thanks, Greg. So, I'm Faye Sutherland and I head up aosphere's Rule Finder Shareholding Disclosure Service. For those of you listening today who don't perhaps know what that is, it's an online legal tool which will look at the disclosure obligations across the globe, so in over 100 jurisdictions. And one area we look at is precisely what Greg said, is, how do these disclosure rules apply to investment managers? And obviously the normal disclosure rules do often apply to investment managers, but it's a much more complex area, as Greg, you mentioned, because of the different entities that are involved with a manager. So, for example, the fund or an account investor or a custodian even. And also because a manager has different types of mandates which give it different discretions. And we need to understand whether or not that triggers the disclosure rules. So I think, Greg, we've identified some key questions which will help to highlight some of those issues.
Sure, this will be great. I have a little bit of experience with this myself, having researched some of these rules in the past. And this area, how you attribute your holdings that are notifiable, that are disclosable for shareholder notification purposes, is probably, I would say, the most difficult area, the most complex area, the area in which it's the most difficult to get meaningful answers from regulators that can apply across the board, because a lot of times those answers really don't exist. The regulators themselves can't give you a quick answer. So really appreciate you being here. I suppose the first of these questions is kind of, the most obvious one is how would an investment manager or a fund rolling up underneath that investment manager sort of determine or understand whether they have a disclosable interest?
Yeah. So we're really at the first stage of the process. And I'd say that the key question an investment manager needs to ask itself is, what type of mandate does it have? So its mandate for managing its holdings of the funds, does that give the manager investment discretion or discretionary voting control? Perhaps the mandate gives them both of those things, but it's delegated one of those away to a sub-manager. So really look at the mandate and what that provides for. And then once you know that, then it's the much more difficult questions of, first of all, you need to work out, well, where might I need to make a disclosure? And that's actually a whole separate question. We could do a whole separate podcast on that. So we won't deal with that today. But once you've identified the relevant jurisdiction, you need to think, well, does that mandate and the discretion that it gives the investment manager, does that trigger a disclosure obligation in the relevant jurisdiction? And this really is, as you've highlighted already, Greg, it's a country by country analysis because each jurisdiction will have its own disclosure rulebook. And some of those countries will deal with it in a really specific way, written into the legislation or with regulator guidance. And that's great. And then others, they won't. And it's really about applying the general principles of the legislation to the investment manager scenario. And that's where it gets really difficult. So I think that said, although I've said it's a country by country analysis, we could start with the EU because, as you may know, it's got some harmonised disclosure rules under the Transparency Directive. So that does make the position easier for investment managers. So I would say in the EU, it's voting discretion, which is a common trigger. So if an investment manager has discretionary voting control over the shares that it manages for the fund, then it is likely to have a disclosure obligation in the EU.
Right. That makes sense too, right? Because the Transparency Directive in the EU, which governs substantial shareholding, it's really about voting rights. I mean,
absolutely.
I suppose member states, if they want to, can impose additional obligations for notifying if they also have shares that are non-voting. That's really up to the member state. But under the sort of EU-wide pan-European rules, it's focused on voting rights. So it kind of makes sense that you say that it's voting control that determines how you attribute the holdings. Yeah.
Yeah, so that's a good summary. And also you've highlighted the point I was just about to make, which is that there will, despite that harmonised transparency directive and the sort of the general position in the EU, there will be some national differences in the legislation. And we can talk about some of those a little later. And they really come up where countries have decided to sort of gold plate the rules. That produces some complexity, not just for the manager, but also for the funds. But we'll talk about that a little later. And then really the other point I wanted to make about the EU was do check whether or not a manager has an exemption from disclosure. And these are quite rare. So I would say exemptions that are specifically for investment managers are rare, not just in the EU, but across the whole world. But there are a couple that I just wanted to mention because they come up in the EU. First of all is Italy. You may remember, Greg, that there's a exemption for certain types of fund managers. It's only a partial exemption, so you still have to disclose, but you just get an exemption from disclosing at the lowest disclosure threshold. Do check the criteria because you have to be a certain type of manager to fall within it. And also it's a little bit tricky in Italy because the exemption only applies to certain types of holdings. So do check, the criteria before you rely on that exemption.
Interesting, because we've heard about a couple other big jurisdictions, but Italy is one to take note of because you don't hear about that one quite as often. So that's interesting.
You don't, and it's got low thresholds in Italy, so it's worthwhile looking at it because it does exempt a manager from disclosing at the lowest threshold if you fall within it. And the other one, just to mention, is the UK. Obviously, we're no longer part of the EU anymore, but it's worth mentioning just because it's quite similar to Italy. Again, you have an exemption for certain types of managers from the lowest thresholds. You still have to disclose at 5 and 10%, but you get an exemption from those, 3, 4, 5, 6 in the UK in relation to UK issuers. Again, check the criteria for that. And as I say, exemptions aimed specifically at managers are quite rare, but those are two sort of key ones to look out for. So I think the position in the EU is slightly simpler, but really it's when we go outside the EU that the position becomes much more diverse. And here we're really looking at a whole variety of disclosure triggers, which may bring an investment manager's mandate within scope of the disclosure rules. So let me give a couple of examples. You may have the disclosure rules being triggered by beneficial interest. So, for example, in South Africa under the Companies Act, and you need to know, well, does my mandate constitute beneficial interest? What is that? Or you may have a much wider trigger, such as an interest in shares. What does that mean? Is that triggered by my mandate? And Hong Kong is a good example of that, where it has a very broad disclosure trigger. It's going to capture lots of different interests that go beyond discretionary voting control. Or it may be something narrower, such as legal title. So, for example, in Vietnam, where you would think perhaps that would scope out the investment manager, but there's still considerations for the manager even in that scenario. And I use these terms, legal title, beneficial interest, but obviously they mean different things in different jurisdictions. So and this is where the country by country analysis really comes into play because, you may have beneficial interest in South Africa, for instance, but beneficial ownership in Bangladesh. And those two things mean different things. And so a mandate that triggers a disclosure obligation in one jurisdiction may not trigger it in another. And I think in relation to this first question, that's the key point to take away, is that the same mandate can produce a different disclosure outcome depending on the jurisdiction that you're looking in. And that's why that country by country analysis is so important.
Sure. You can have a set of holdings and can't expect the rules about how you attribute those holdings to your investment manager in one jurisdiction to really be the same in many others, which makes it particularly challenging. If you, let's say, now we were talking about voting rights earlier in the Transparency Directive in the EU, but as you know, you've had a lot of experience with this too, because you deal at aosphere with so many different jurisdictions. There are some areas of the world that require disclosure, not just based on your voting interests, but holding shares that may not even have any voting rights, holding interest without voting rights. Does that come into play for this issue? And if so, how does it come into play?
Yeah, so having voting discretion sometimes is seen as the key consideration. I think that probably stems from people's familiarity sometimes with the EU Transparency Directive and the presumption that it's voting control, which is the common trigger. Whereas I would say outside the EU, obviously own disclosure rule book. So the disclosure rules may apply to things other than just voting shares. And this, I think, is where, one of those complexities in the EU comes into play, where jurisdictions have decided to gold plate some of their rules. You might have a jurisdiction that has in the EU, which requires you to disclose not just your voting shares, but also your holdings of other shares and share capital, for instance. And that's where, it has an impact on the manager and also the fund. So, for example, Finland has a requirement to disclose shares, both voting and non-voting. So those are disclosed by the fund, whereas the manager discloses its holding of voting shares and discretionary voting control. So there's nuances there. And obviously looking outside the EU, you're going to get some jurisdictions which have a disclosure trigger which has nothing to do with voting control. It might be investment discretion, for instance. It could be very broad and go beyond voting shares and voting control.
Interesting. So we've talked about a lot of different terms that can be relevant according to the local legislation. So beneficial ownership, beneficial interest. I think Australia has something called relevant interest, which is no doubt, probably important when making filings there. And then we talked about, also holding interests in not just voting interests, or voting shares, but interests that don't carry voting rights, where you don't necessarily have voting discretion. Like you said, you might have investment discretion. So once you have, to the best of your abilities, tried to, as best you can, settle all those matters, because it can be difficult, you're then faced with the prospect of submitting a notification. You want to populate your notification form, get that in the proper way by the deadline, which obviously some of these deadlines can be very quick. Do we need to bear in mind any of these issues in actually completing the form itself?
Yeah, so just as we find that sometimes, or quite often actually, the national legislation doesn't specifically cater for managers and it's about applying the general principles to the manager's position. So once we get to the form filling stage, we also may find that the notification form is silent on these points, and we need to work out, well, what do I need to include in my form? Do I need to identify the funds that make up the manager's holding? And here, again, we can split between the EU and the rest of the world. So the EU, because the Transparency Directive is a well-developed set of rules and we have a lot of regulator guidance on it, the regulator here, ESMA, has given some helpful guidance on this particular point. Whilst the disclosure rules can vary in different jurisdictions across the EU, the general picture is that for a manager, it has to identify the funds in the disclosure form, but not all the funds, only those which trigger the lowest disclosure threshold. So that's quite a nice, clear rule. Obviously, it can be open to individual jurisdictions to amend their disclosure form as they wish. But that's the general rule and the guidance from ESMA. Outside the EU, again, as we were talking about in the first question, the picture really is more diverse. And I would say that there's no common theme, apart from the fact that quite frequently there's no guidance in the form itself. So this is something where if there's no regulator guidance, there's no specific, pointer in the form as to how you're meant to deal with funds, identifying funds. It's then a question of looking at the national legislation and thinking, well, is there anything in the national legislation that points to a requirement for the manager to identify the funds in its disclosure form? And that's a trickier question and something that we at aosphere would be asking local council to, assist with by reviewing the legislation and telling us, what do we think that we have to identify for managers in the disclosure?
Yes, that's a huge value add. I can testify to that, having local council look at the national legislation on that issue instead of us having to do it. So that's great.
And sometimes I think that you find you might get past the first hurdle of, well, I know now what I have to identify in the disclosure form. I know which funds I have to identify. But, there might be then country-specific nuances layered on top of that. So if the manager has had to identify some funds in its disclosure form, whether that's all of them or just some of them, what happens if that list of funds changes? Does that trigger a fresh disclosure by the manager, even if the manager's aggregated holding hasn't triggered a new threshold in its own right? That's a sort of another complication that we ask local council. Sometimes, we might find that that's dealt with in the legislation, but I would say more often than not, that's only in the most sophisticated, in the jurisdictions with the most sophisticated legislation and regulator guidance, with it's a question, again, that we have to ask local council.
Yeah, indeed. That would be a challenge, wouldn't it? Your holdings on the aggregate do not change, but something about the chain of control or the chain of command in your structure for your investment manager and your funds changes. And then perhaps just because of that change, you need to make another filing. Interesting. So we've talked about attribution of holdings, trying to determine who is the responsible party or what is the responsible party that must notify that's considered to be holding these interests. Talked about filing the form. Now, there's a separate question, and this sometimes gets confused with the first thing we discussed, but once you've determined who is deemed to hold the interests, a separate question can be who actually has to make the notification, because From what I understand, that's not always the same question. You could have, in some jurisdictions, may view the sort of attribution issue in roughly the same way, but allow different parties to notify. Is that correct? Am I understanding that correctly, that can be a little bit different?
Yeah, absolutely. So I think there's a couple of questions here. So it's, first of all, if a manager has to make a disclosure, you would expect the manager to be making that disclosure. But does that mean that any funds and any sub-manager involved, are they off the hook? Do they also have to make a disclosure? That's one point. So we might be getting into multiple disclosures for the same holding. And I would say do investigate that, because just because a manager has disclosed its interest in the managed shares, that doesn't mean that a fund and a manager doesn't also have a disclosure. We might see multiple disclosures there, simply because the disclosure rules in a jurisdiction may be triggered by quite a wide range of interests, which brings different parties within scope. So again, Hong Kong is a good example of that, where a manager may have to make a disclosure, but also a sub-manager and a fund and the custodian as well, just because they all trigger that interest in shares concept. And again, the EU, we've just talked briefly about national discrepancies there, again, to highlight the point that just because a manager in the EU is making the disclosure, don't think that the fund is off the hook. It may be on the hook because of, say, a share capital test or a direct holder test. So I think those are quite complex points. But then also the point that you made, Greg, is that if, for example, the manager's mandate means that the investment manager does not have a disclosure obligation in that jurisdiction, but the fund does, is it actually because of the nature of the fund? Is it actually the manager that does it on behalf of the fund? And again, that's another question that needs to be investigated in accordance, with the national legislation.
Right. I suppose one of the questions there is, can the fund appoint someone to be its agent for that filing purpose? Yeah, if the fund has crossed the threshold, but the manager has not, like you said.
Yeah. Or the manager just may have no notifiable interest. It may sit with the fund, but in practice, the fund actually is not able to or does not make the disclosure. It's the manager that does it in the name of the fund. So that's another element to consider. Right.
And then, of course, the attendant things you need to do on the form that you file to sort of show that, which is also, as you mentioned, going to be different in a lot of jurisdictions. Okay, so kind of never-ending complexities here, but thank you. You've definitely clarified a lot of that for us, Faye.
Thanks, Faye and Greg, for the insight into how you like your regs in the morning. For CSS, this is Natalie Silverman.
This has been another episode of Coffee and Regs, a CSS RegTech podcast series. Make sure you catch every episode by subscribing to our podcast on www.cssregtech.com or through your podcast platform of choice. Thanks so much for tuning in. This podcast is brought to you by Compliance Solutions Strategies and is for general information purposes only. All rights reserved.